as national security operatives. They don't describe them as police officers, but they just describe their conduct as unlawful, and they describe how they came into the house, what they did, and to that extent, they think it is an unlawful conduct for which the court must intervene to grant the relief sought.
And this suit by Ken Oforiatta cites 2 senior police officers.
So the 2 are the defendants. Right. However, when you read in the statement of claim, you'd find that they said the 2 were together with some 12 other persons. Okay. Those 12 persons have, however, not been indicated on the face of the writ of summons. Amongst the 12, 9 of them, according to the statement of claim, were soldiers.
Okay.
So that's why I was making the case that this fits the reports of a raid
of what we
are seeing on the screen.
Oh, okay.
One would have expected that maybe specific names would have been mentioned, I mean, on the back of what we do know. But you do not see that mentioned there except the 2 persons who appear to be the defendants.
So the only time these persons we are seeing on the screen are allegedly, as it were, referred to or captured in the suit is the 12 other persons that the suit talks about.
Yes.
Who were soldiers.
Yes. Not all 12. 9 of the 12 are soldiers. So it means that, 2 plus 9, that's 11. There's a last person who is supposed to be in the picture.
Well, but
however,
that person
the
was
suit
not
is
named.
against the 2 persons.
The 2 persons.
Yes.
These the 2 senior police officers.
Exactly.
Okay. Whom we don't see in the video, by the way.
Well, you see people in the video, but you are unable to tell whether there's a police officer in there or not. What we see now,
well, there's a fundamental question that comes to mind as to the other question he raises in the suit is that they didn't have the warrant to do so.
Yes, because they purported to have come to conduct a search, and he says that that purported search was without a warrant.
And the warrant, if so possessed, should have been shown.
Exactly.
Okay, but what I want to find out right now is whether it is regular practice for the National Intelligence Bureau or National Security, for that matter.
That's if they were.
If they were.
Yeah.
Because the statement, and it's good that we clarify and put this in perspective, that this suit does not describe these 2 as national security operatives.
No.
But then it only relates to them as being part of a group of people who raided his house.
Exactly.
Okay. Richard Commodore is a security analyst, he's a former operative of the National Intelligence Bureau, now, well, formerly BNI. But Dennis, stay with me, because I'm going to come back to you. Mr. Commodore, appreciate your time. Thank you for joining us here on Ghana Tonight.
Thank you. Thank you.
There's a matter of law, and there's another issue of security to this conversation. So I'm going to dwell on the security part of it with you because of your experience in how this institution works. Can an exercise of a sort be conducted without a warrant? I mean, is it a practice to be done of anything of a sort?
Okay, so as a standard procedure, law enforcement officers in general, or the BNI, with an investigative mandate, can arrest you with or without warrant. And they can also search and seize whatever items they are looking for with or without warrant. When they activate searching without warrant, it means that it becomes a state of emergency. Or if they want to arrest you without warrant, then they will explain the conditions under which they are arresting you without a warrant. But I want to believe that filing the suit against them, if the officers who entered his house were acting in their personal capacity, then the particular officers could have been sued. But if they acted in the name of the state, then the state should be the one rather who is being sued and not the particular officers, unless it has been established that the officers acted on their own and they were not acting on the authority of the state. Because officers, as law enforcement officers, when they act on behalf of the state, they do not bear the liabilities. It is the state. So that is where we are. And I'm happy that you were raising several questions with the suit in a manner and a form it has been serving to the general public. But I can tell you, as a standard procedure, all law enforcement officers, from the FBI to the CIA to the MI5, MI6, the BNI, the research department, the police, and even the military intelligence, you can't be arrested and you can't be searched with or without warrant. And whichever option they adopt, they will explain it to you why they are adopting that option. So that is where we are after.
I see, and I asked this general question, not in direct reference and specificity to this particular case. You know, I asked it in general terms, how the standard operating procedure is with these specific institutions of security nature. But you say that if the officers in any circumstance act in their personal capacity, they can be sued. Otherwise,
yeah, they can be held liable.
Otherwise, the state must be the one being sued.
Exactly. If they act in their personal capacity,
okay,
they can be held liable for whatever damages is seeking to claim. But if they act in the name of the state, it means the authority to act is also derived from law, which gives them the power to address some of these issues, especially when there are crime investigations involved and evidence collection become one of them, or prosecution become an option on the table. You can't be arrested, you can't be searched, your premises and your properties can be searched with or without warrant. But whichever option they choose, you will be explained to. For instance, you might be traveling across the globe and at customs, across you check in your bags, and American Embassy Customs can decide to open your bag in your absence. And what they do is that once it is done, they fill in the form and leave in your bag and say they were the ones who opened your bag in your absence, because remember, you might have checked in the bag and you will not be there whilst your bag is open. But once it's part of what they do as a random check or as part of their investigative procedure, things could be done in your absence, but it's a standard procedure that you can be arrested without warrant, and your premises can also be searched with or without warrant, particularly when there are crime investigations involved and they are operating under the state of emergency.
Well, but is that standard operating procedure that you talk about? And I want to understand under what circumstance can a residence or someone's house be searched without a warrant? Because you say that it is part of the SOP that this action or exercise can be undertaken with or without a warrant, correct?
Correct.
So under what circumstances is it done without a warrant?
Yeah, so if Richard Kumado has come under investigative interest, or Richard Kumado has come under national security interest, and I have become a person of national security interest, or that I have become a person of crime investigation interest, the BNI or the police can walk into my premises in my absence. Predominantly, they will want to come and show me the warrant and say, we are from so and so, introduce themselves as a standard procedure and say, we are here to search your premises, or we are here to arrest you based on ABCD. Or they may decide to do it in my absence. And once they have done it in my absence, what is required is to indicate why they came there and what they have done and the purposes for doing it. But in a democracy where rule of law is applied, or the application of rule of law is one of the cardinal pillars that sustains a democracy, and people's rights are supposed to be respected, the BNI in particular will always explain their actions. And I'm saying that my premises can be searched without warrant. And when I come under security intelligence interest, and they needed some documentation that are of interest to them in carried out their investigations, and I have locked up my place and I have traveled to America or Britain or Canada, they can break into my place and search the place. And whatever documents they take, they will indicate that on this day, we search your premises and these are the documents we are taking. And you might want to follow up with your lawyers to come and explain ABCD. So it's part of the standard procedure. But then these are legalities and these are operational structures. And right, where you think your right has been infringed, that is why you want to test it at the court of law.
Mr. Kumado, appreciate your time on this, and I thank you. Thank you so much for joining us as always. Richard Kumado is a former operative of the BNI, now National Intelligence Bureau, and I need to apologize to our viewers on Facebook and on YouTube. We got the notice that we were not on when we started the program. Apologies, there were some technical hitches, but we're live on Facebook and on YouTube right now. So kindly forgive us for that late start of the stream on Facebook and on YouTube as well. But Dennis, before we round up, I mean, there's obviously some legal questions that should and would be asked going forward, regardless of the SOP that we talk about, as explained by Mr. Kumado, is it not? Precisely
so. So, moving forward, the former finance minister, through his lawyers, will be seeking to get the reliefs that have been endorsed on the writ of summons. And in doing so, a lot of questions will come up, just like Kumado raised the issues of whether the said police officers were acting on their own or they were acting under the instruction of the national security, whichever way it is. And if that comes to question, then it brings us back to the issue of who really these people are and why the national security itself has not even been named in this particular suit. We do know, for instance, that when this incident happened, the majority leader is on record to have apologized to the finance minister and to have indicated that he got information that the exercise was carried on by the national security.
Right.
But as it stands now, this is a different matter altogether. Two police officers have been directly sued in this particular matter.
And their names so called.
As to whether they will seek the cover of the national security in this particular one. The coming days will tell how the whole suit unfolds, Alfred.
Certainly. And Dennis, thank you so much for joining us always with this legal aspect of things. But coming up next here on Ghana Tonight, because this is a matter that is going to travel the long haul, so it's just a beginning of a conversation on this. But coming up next here on Ghana Tonight, the Supreme Court has decided it will give convicted member of parliament for the Akwatia constituency, Ernest Kumi, a listening ear on why he wants the court to quash the conviction of the Koforidua High Court. We've got updates for you on this particular one here on Ghana Tonight, and also the reactions so far to this particular position and decision taken by the courts. The Supreme Court earlier today has, in a 4-1 majority decision, ruled that it will hear the case of the Akwatia Member of Parliament, Ernest Kumi. Despite his contempt conviction by the Koforidua High Court, lawyers of the Akwatia legislature filed a motion seeking to set aside the decision of the High Court without first purging himself of contempt. So, but the court first had to make a decision whether to hear him. Now, having made that decision today, the court will hear him on his case on the 26th of March. Bernard Bediako Beidou is a lawyer for the petitioner. That's the NDC parliamentary candidate in the Akwatia constituency, and he's going to be joining us on the telephone shortly to have a conversation on the developments so far. But what we do know is that Justice Gabriel Pwamang dissented, so he was the only dissenting judge on this case, and the four went the same direction. So that's the development on this right now. And let's go on to the telephone now, and we're joined by the lawyer for the petitioner, the NDC parliamentary candidate for the Akwatia constituency, joining us right now. Appreciate your time. Thank you very much, counsel. For good evening.
Good evening, and thanks for having me.
Great. Now, today the court took a decision, and was there did you make a case as to the path that the court took today in ruling that despite the Akwatia MP not purging himself of contempt, he still should be given a hearing?
Okay, so you'll recall that at the last hearing date, this matter came up, and it had to do with whether the contemnor, he is not an alleged contemnor any longer because he's still a convict. No court has vacated that conviction. So the contemnor should be given a hearing or not. Remember that was, that came from the bench. I or my client or no other party, brought this up. We were ready for the application, and from the bench, when I say the bench, the judges then put that to him, whether he should be given a hearing or not. Back and forth, we were asked to, submit address the court on whether he should be granted a hearing or not. Now, when we left, we were of the considered opinion. Now, you would also recall that just before we left court on that day, there was this viva voce. When you say viva voce, an oral application by counsel for the contempt applicant at the Supreme Court that the relief they were seeking in the substantive application, the judges should grant, or the court should grant that relief as an interlocutory or interim relief, so that the hands of the High Court judge is tied, and so that he doesn't proceed to sentence the contempt. I mean, even before the Supreme Court hears the application. So that in itself, in our considered opinion, was a hearing they had offered him, because you see, if the application is seeking to invoke the court's jurisdiction to tie the hands of the learned High Court judge from sentencing him, and that application is granted when they had not even filed an application properly so-called. In fact, the main application had not even been served on us. So I got up and told the court that we had not even seen the application, because it was that morning they sought a statutory service application for the processes to be served on me in open court, and the order had not been drawn. So I had not cited the processes. I told the court, and by a decision of 4-1, they said they would still, I mean, when I say tie the hands of the learned High Court judge, you understand, so he doesn't proceed. So we were of the considered opinion that there was no need to file anything. Indeed, we are also not against him being heard. In fact, that's why we are in court. We want him to be heard so that we can respond to it, because we know the case we are presenting. A lot of factual inaccuracies have been put out in their case. That's our view. And we are looking forward for an opportunity where we would correct the factual inaccuracies and the law. And so we were prepared. So we didn't file anything. In essence, we were not opposed to him being heard. So when the case was called today, yes, the court asked whether we had filed anything, because they had filed yesterday and we were served. And we told the court that no, and that we leave the decision whether he should be heard or not, because it came from the bench. It didn't originate from our end. So we told the court that for us, we have no problem if we are prepared for the application. So if he will be heard, we are prepared to proceed with it and answer to whatever application they will put forward. And so we leave it to their discretion. And so it was not opposed by us. We didn't file anything in opposition because we want him to be heard. And then we would have an opportunity. So
essentially, you defer to the wisdom of the courts in this matter?
Absolutely. Absolutely. We defer to the wisdom of the judges in this matter. And so they ruled that by a majority decision of 4-1, they ruled that he be heard. In fact, when counsel started, he was going into the matter, but he was asked by the bench not to, because the matter is the reason we are here. And that whether you should even be heard in the matter or not is what we are here to determine. So going into it would not help. In fact, that is what I came in to say, that if it is going into the matter, we are prepared. But at that stage, we were considering, or the court was considering, whether to even grant him a hearing, which we are not opposed. So if it is the hearing that they are seeking, we leave it to the superior. We say always that their wisdom is superior. These are the law lords. And so that's what happened.
So the hearing for the substantive case is what is going to be heard on the 26th of March?
Absolutely. Absolutely.
Okay, but how about the contempt case as well? When is it going to be heard?
Okay, so there are two applications, and both are going to be heard on the same day, the 26th. I mean, there's a certiorari application filed on the 8th, 2 days after he disobeyed the court, on the 8th of January. And that matter, that one has to do with the interim injunction, where he says that the court didn't have jurisdiction to even grant the interim injunction. And so that is one. And then the conviction on with regards to the committal for contempt. And so there are two different applications. And usually when we go to court, we do both. So one is called and the other, even though they are some ways linked. And so if your reporters were in court, they would realize that at the tail end of the session, lawyer Gary, lawyer for the contempt applicant, prayed the court for a consolidation of both cases because they have similarities. but the court said it's not something they would consider now, but when we come, we would determine it. We have a view on that, but when the time comes, we will express it. So on the 26th, both applications will be heard. That's 2 weeks from today.
Let's see. Well, we'll wait for that date. And so we have two cases to be heard on this, the 26th of March. That's the substantive case, and then also the contempt case as well, also on the 26th.
Well, but well, maybe for lack of a better word, the substantive, you see, because what he filed was, yes, what he filed was an application with regards to a certiorari, judicial review in the form of certiorari against the interim order, the interim injunction.
Okay.
You see, I would prefer you use that because there are other issues. If you say the substantive matter, we have our issues with that. It is on the interim injunction.
Okay. And so, in fact, it's just some 2 weeks away from now, so we'll see how things play out on it. But I thank you very much for also having to speak to us and bring some perspective to what happened in court earlier today. We get the understanding that the full ruling will be made available by the 21st of March, correct?
That is so. That is so. That is so. You know, there will be, of course, there is a dissenting ruling as well. So there will be that for the dissenting and then the majority as well. So the 4-1 both would have its own reasoning, and that will be available for us. And going forward, you see, whatever happens at the Supreme Court becomes a guide to the lower courts, okay, because of the hierarchy of the court system. And so beyond every other thing, we would take a cue from it. So it's good you go for a copy, read it, so that whatever it is, you will be guided going forward. So it is not always about where it falls. It is also about learning. Yes, we do not really, and I must emphasize that we have never had any problem with him being heard because we know the case we have. And so we want him to be heard so we can respond. That is what we have always been praying for. But the court has its own discretion. So we abide by their wisdom.
Okay. Thank you very much for joining us. Lawyer Bernard Bediako Bedu is counsel for the NDC parliamentary candidate for the Akwatia constituency, the petitioner in this case that we're talking about. Thank you so much for joining us here on Ghana Tonight. And those 2 dates is one that we'll watch. But coming up next here on Ghana Tonight, President John Dramani Mahama reiterates his commitment to maintain a lean government as a cost-cutting measure. But is it just about the number of ministers so appointed? That's the conversation we're going to have right now here on Ghana Tonight, because just reducing the number of ministers to many who have been looking at the real cost of governance may not just be enough, even though it is a good signal, good measure taking. But they're flipping it around and going beyond just the reduction of numbers to look at the real cost, that's expenditure, that could be cut as well in other areas of the governance structure that we have as a country. So earlier today, President Mahama justified the appointment of the 30 political appointees at the presidency, reaffirming his commitment to a lean government whilst ensuring fiscal prudence. The president's comments comes in the wake of the claims by the Damongo Member of Parliament, Samuel Abujinapo, that the president has appointed the largest appointees in history. Speaking at the swearing-in of some 13 deputy ministers and a minister of state, the president says as long as he remains president, his appointees will be nowhere closer to the army of appointees by his predecessor. Take a look.
The swearing-in of this batch of 13 deputy ministers and 1 minister of state brings us closer to achieving the full complement of ministers. This week, I'll submit a final list of 4 deputy ministers to achieve the full complement of 60 ministers that we promised. The same commitment to composing a lean government has found expression in the appointments made at the presidency so far. So far, I've appointed 27 presidential staffers to various roles and 3 persons as directors of important governmental initiatives, bringing the total number of political appointees so far to 30. This list of 30 is pending approval from the Council of State. At the last count, there were 336 political appointees at the presidency under the previous government. While we're in the process of recruiting supporting staff to enable the full functioning of our presidency, the numbers will come nowhere near the army of people that were hired under the previous government. Our commitment to a lean government is not merely about reducing the number of ministerial appointees or reducing the numbers at the presidency. It is grounded in our firm belief that government must exercise fiscal discipline by ensuring that public resources are used efficiently and responsibly. As long as I'm president, my policy will remain clear: a lean, efficient, and results-driven government, of which you have just become a part.
The president talked about the number of ministers, that's deputy ministers left. He talked about the reduction and then also the appointees at the presidency and the commitment to a lean government. These are the numbers, but we have a conversation beyond the numbers tonight. This is it. 56 so far appointed ministers and deputy ministers. He has also reiterated the point that before the end of the week, the remaining 4 deputy ministers will be announced. And he explained that not all ministries would have deputies. So we're yet to know those specific ministries, but we'll wait for the full complement of the deputy ministers. Then we can now know the ministries that will go without deputies in this administration. But we have the total substantive ministers, that's 43. So far, 13 ministers and deputy ministers have so far been named. And then also the 56 in total, 4 remaining. Before end of week, we'll get to know. But beyond these numbers, the likes of Bright Simmons, Vice President of Imani Africa, says cutting down the numbers of ministries and ministers is thus an exercise, as he put it, in reading the sentiments of the public and in being responsive, which is good, and not so much about lean and efficient government reforms per se, in his view. But being a listening government can have its own rewards, separate from efficiency gains. So the emphasis that he puts there is on the efficiency gains that drives this conversation beyond the numbers as we have it right now. And he goes on to say, to actually move in the direction of government efficiency, you must act whether the thousands of workers in collapsed ministries would leave the government payroll or would simply be redistributed. That's another conversation as well. Felix Kwachofosu is Minister in charge of Government Communications, spokesperson for President John Dramani Mahama, is going to be joining us on the phone in a bit. But we also have Alfred Ocansey, who's a data scientist, looking beyond just the numbers. What we also see here, the talk about efficiency and whether these persons who are going to be affected by these reduced ministries will just be redistributed. How does that reduce the cost? Alfred, good evening. Thank you for joining us.
I'm happy to be here.
Hello, Alfred.
Can you hear me?
I can hear you clearly. Now, so this conversation beyond just the numbers, and Bright Simmons also brings in the bit about, yes, this is a reflection of a listening government. It has its own rewards, but he's lifting the conversation into the area of efficiency gains as well. How do the numbers look like?
Yeah, I think there's, Bright makes some great points there. And there are a number of ways to look at this, right? Even within the government machinery itself, right? How much is being cut relative to, say, 2024 levels, right? So if we look at the actuals from 2024 and then compared to the budget, that's one way of looking at it. The other way also is you know, usually when the government does the budget, what it does is it also projects out, right, over a number of years, 3 to 4 years. So one of the ways that you can also compare is to compare what budget 2024 was saying the trajectory of government expenditure was going to be, and then comparing that to the to what 2025 is budget 2025 is projected. So those are some of the ways. But beyond that, of course, outside of the government machinery itself, there are other areas to look at, right? And one of the key areas is the state-owned enterprises. So, for example, when you look at 2024 levels, we still haven't seen the full 2025 budget statement. So I'm only still using the 2024. But when you look at the total appropriation, right, the central government's total budgeted expenditure, it was about 260 billion. Right. But when you look at the budget of state-owned enterprises, it is almost double that. It is actually over double that amount. Right. So, and we know that the state-owned enterprises themselves, they generate their own internal revenue and all of that. But we have to look at efficiency there too, because if the size, the budget size is double that of the central government, then there should be some opportunities for cuts there as well. And so that is one of the ways that I think we need to be focusing on as well in terms of what's happening in the SOEs and how come they have all this spending that's happening. Because some of the SOEs also even get their funding from the central government through some of the transfers, for example, GNPC through like the petroleum revenue transfers and all of that. So that's one of them. And then the other thing that is also draining our budgets, right? And it's when you look at what is happening with ECG. So yesterday the minister gave us actually final numbers for 2024, and this is the budgeted number. We're estimating to spend 17.5 billion just for energy sector shortfalls. As it turns out, we actually ended up spending 20 million. The minister said 20.8 billion cedis was spent on energy sector shortfall. So this is money that would go towards others. For example, the budget of about 20 ministries as of at 2024 levels was about 15.8 billion. And here's a case we've spent about 20.8 billion just on energy sector shortfall. So that's also an efficiency thing. And we know what has happened with ECG in terms of under declaration of revenues and all of that. So I think that's also one of the things that we should be looking at. So that in terms of the SOE's management. And then the other part is also about debt management itself. So for, again, using 2024 levels, we're estimating about 56 billion cedis spending on interest payments alone. And then when you look at the budget of all those 28 ministries, excluding the ones that no longer exist, actually all the 28 ministries, including those that were there that no longer exist, we are looking at about 87 billion budget. So you can see that there are these different ways that I think we should also be focusing on, debt management, the SOEs, and then the efficiencies there. We haven't even talked about the capital and the contracting and everything that happens in those SOEs, because that's also the avenues where we know that sometimes there's like, more practices when it comes to procurement and all of that. So I think those are some of the areas that the focus should be, of course.
I see. But then again, we see that a lot of the emphasis is on the number of ministers, and that's the various ministries as reduced as well. We did have some explanation earlier from Felix Kwachofosu that some of the collapsed ministries would have some of them would have their staff distributed amongst some of the other agencies as well. How is that going to impact on that commitment and the objective of cutting down expenditure and cost as well, alongside the reduction in the numbers?
Yeah, so I mean, we've heard about the fact that there wouldn't be ministers, and so like whatever emolument and compensation that is associated with those ministerial positions will no longer be there. So that's one of the savings that they are mentioning, which is why I'm saying that that's good, but we need to compare. Like, we need to look at 2025 compensations and then compare it to 2024, because if we're going to be redistributing, how much actually are we saving, right? How much are we actually saving? So until we get those numbers to actually be able to figure out, like, this is how much we've cut down, because yeah, it's great, we've cut down the numbers in terms of like counts, right? But the city amount associated with those positions, we need to really see how much we're actually saving in the end. And one of the things that I would also say is that in terms of trying to see how lean or how government is cutting spending, we should also be focusing on like what is called the primary expenditure, right? So excluding interest payments, because we are resuming paying of debt and stuff, a lot of it this year. It wouldn't be fair to compare to last year, right? But outside of that, like your compensation, your goods and services, your capital expenditure, we need to be able to compare that to 2024 levels and see by how much have we actually cut. And those are details that we would have to look at once we get the full budget documents released by government. Which, by the way, I'm surprised that's not released yet, because generally by this time we should have had the full complement of the budget document.
And it's one question as well what we'll be asking going forward. And Alfred, appreciate you for this. Thank you. Thank you so much for joining us here on Ghana Tonight. Alfred appears as a data scientist. There's going to be more of him in the coming days here on TV3. But we're going to go for this quick break. When we're back, we'll talk illegal mining. There's a development, so stay with us. Well, coming up next here on Ghana Tonight, let's move straight into matters of illegal mining and the effort towards stamping or clamping down on the menace. Let's start off from some part of the northern region for good reason, because illegal mining activities in the Bambo area of the Savannah region is rife as portions of the Black Volta River has been heavily polluted. 13 people, comprising 5 Chinese and 8 locals, were arrested earlier today in a swoop led by the Savannah Regional Security Council. 9 excavators and other mining equipment have also been impounded by security operatives. My colleague Christopher Mwakon is going to be joining us in a bit to have a conversation on this particular issue and this development. And these are the Chinese you see on the screen there, who have been arrested, 5 of them, and also some 8 locals were involved in illegal mining. And Christopher Malcolm is going to be joining us in a bit. I will have a conversation on this. In fact, some weapons were retrieved from them. That's one of them you see on the screen as well. And these persons have been arrested by the Regional Security Council, who led the clamp down on them in the Bambo area. And this comes after the resolution by the Security Council to, as it were, clamp down on illegal mining in this area. Now, before Chris joins us as well, we got a development in the Ashanti region as well, because the Asante Otumfuo Osei II has again distilled Nana Amofa Chumesi II, the man you see on the screen there, chief of Mpa Saso #2 in the Ashanti region, over multiple allegations, including his involvement in illegal mining activities. Other allegations include his questionable royal lineage and a lack of oversight and accountability to his community and traditional leaders. The chief, he has reigned for 41 years, was found guilty after he appeared before the Asanteman Kumasi Traditional Council at the Menchia Palace over the said allegations. That's the man you see kneeling down in this picture, or he's nailed down there. The central issue surrounding his distillment was reported to be his involvement in illegal mining and activities in that particular Mpasaso community, which has led to the destruction of water bodies in the area, as we do know. So this is yet another distilled chief by Otumfuo Osei II for engaging in illegal mining. And the list keeps growing. The last time we checked, we recalled all of them. Just about 2 weeks ago, Otumfuo Osei II distilled another chief, and this one as well, adding up to the list. Now, let's go back to the Savannah region. Christopher Malcolm has been watching how things are playing out in the Bambo area. We understand the Black Volta has been heavily polluted. Chris, worrying development we're seeing on the screen there. Now, what can you tell us about the weapons that we saw in this video that were retrieved from these persons? What exactly did the police tell you about it?
Yes, so after it has to do with the illegal miners that were arrested around the Bambo area after the Savannah Regional Security Council, led by the Regional Minister Salisu Diarobi, conducted a swoop in that area, and these weapons were retrieved on some of the suspects who were engaged in these illegal mining activities. And as we speak, they have all been sent to the Bambo police station, where they have been put into police custody. Tomorrow, the Bambo police will work on their cases and forward them to Damango, the regional capital, for them to be processed for court.
The Regional Security Council as well, you spoke to the chair and for that matter, the minister. Now, how are they moving with this particular clamp down? Because he talks about the Black Volta being heavily polluted. And we understand, based on your earlier reports, there are multiple scenes of this illegal mining taking place along the Black Volta, is it not?
Yes, so they are not just doing it at one place. They are doing it at different places along the Black Volta. And so the regional minister has cautioned and has also emphasized that the Regional Security Council is poised on clamping down on this illegal mining activity. And so they are going to intensify the operations and also ensure that these perpetrators are arrested.
See, but how widespread is it, especially with the involvement of the Chinese that we saw have been arrested? This time, 5 out of the 30 main Chinese. But with your work in that area, how widespread is the involvement of these foreigners in this illegal mining?
Yes, so Alfred, you remember that somewhere last year, September, we did a report on the Black Volta where we said that some locals were involved in the illegal mining activities and some farm machines were burnt. This time, excavators have been sent to these areas, and what they do is that they block the river, portions of the river, to be able to dig deep. And if you go there, it's a nice, so the entire environment, that area has been destroyed and the water heavily polluted.
Chris, appreciate you for this. And no, this is one that you keep an eye on how things are playing out in that region. Christopher Malcolm is our Northern and Savannah regional correspondent. I want to say thank you so much for staying with us here on Ghana Tonight. As always, brought to you by Flamingo Paint, Simply Superior, Kel Charcoal Toothpaste, Fresh Smile. I am Alfred Ocansey. Have a good night.
Ghana Tonight is brought to you by